Any mentioning? Item number 1, WC 74 of 2023.
The impugned order of the tribunal does not account for any of the factors which have been stated above, directing the petitioner to participate in disciplinary proceedings as per procedure is a mechanical conclusion on the facts without considering the attending circumstances. We are therefore of the view that the impugned order of the tribunal deserves to be set aside. As a consequence, the charge memorandum dated 9th June 2023 against the petitioner is also set aside. WPCP so and so is accordingly disposed of in terms of the above.
I'm grateful, my lord.
WCT 78 of 2023.
Fine. Only for both of you, we were in the process of dictating the judgment. You have come across a decision. Kindly take note of that. Both of you go through that judgment. If you have anything to submit, 2020 Volume 2 SCC, page 173.
That is with regard to the rules of the game, changing the rules of the game. The facts, you react on the facts, both of you.
Yes. When can both of you come back?
Never mind, it's tomorrow.
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 So.
Learned counsel, although this matter was kept for judgment today, we have come across a decision which according to us would be of some relevance. Stop. The decision is reported in 2020 SCC 173. Stop. Next, learned counsel appearing for the parties are hence requested to consider the decision and come back with their responses tomorrow. Stop. Next, this is matter tomorrow.
Item number 3, case 1 of 2022.
My lord, I am appearing for the petitioner, my lord.
I brief for the state here.
Just
My
one.
lord, this is the application for relaxation of bail condition. Bail has been granted by this honorable court. And
Which is the page?
I have not paginated last document, the certified copy. There are mainly two conditions: to meet with the IO once in a week and not to leave the jurisdiction of the landed trial court without permission.
Yes.
Yes, that point of time when the petitioner moved the bail application, that point of time investigation was in progress. Now the change circumstances is that
the police already filed the charge sheet, investigation is over, charge has already been framed. Now, two conditions all already been framed, and the next date on 1st March is fixed for trial of the case.
What is the relaxation? Once a week?
Must to meet with the IO once in a week.
Yes.
That's because the charge sheet has already been submitted, charge has been framed, so I don't think that it is required. And another thing is that I am a permanent resident of Billy Ground, Swadesh Nagar Billy Ground, which is beyond the jurisdiction of the trial court, but the special court Port Blair. So I have to take permission again and again to go to my own house. I am unable to go to my own house.
And where are you now based? Here in Port Blair?
Here, I am residing in the house of my friend.
Very well. Yes, what do you have to say?
Lordship, condition can be relaxed.
Yes. This is an application for relaxation of bail. Stop. The relevant order is of 22nd November 2023, whereby the coordinate bench, was pleased to allow the application for bail, but on condition that the petitioner shall meet the investigating officer, capitals, once a week and shall cooperate with the investigation. Stop. Next, the petitioner seeks relaxation of this condition, no, once a week, stop, and shall cooperate, delete. The petitioner seeks, learned counsel appearing for the petitioner, next, seeks relaxation of this condition on the ground that the charge sheet has already been submitted and charges have been framed since the passing of the order. Stop. It is also submitted that the petitioner resides outside the jurisdiction of Port Blair, and it is hence difficult for the petitioner to meet the investigating officer as per the condition contained in the order, condition attached to the order. Stop. Next, considering, we have considered the.
Malad, the second condition also troubling me.
What is the second condition?
Second condition, not to go beyond the jurisdiction of the,
Remain.
I have to take permission again and again.
Yes, after one line that.
No, not to leave the jurisdiction of the trial court.
The petitioner is also, the petitioner also seeks relaxation of the other condition, which is that the petitioner shall not leave the jurisdiction of the special judge, NDPS, Port Blair, without permission of the special court. Stop. Yes, what do you have to say to this?
Lordship, I was under the impression that he should not leave the islands without prior permission.
I will not leave the island.
Yes. We have considered the submissions also made on behalf of the prosecution. Stop. Next, we are of the view that submission of the charge sheet and framing of charges are significant subsequent events which call for which amount to a change in circumstances. Stop. The CRM NDPS 1 of 2024 is accordingly allowed and disposed of by relaxation of the condition whereby the petitioner was to meet their IO once a week. Stop. It is, however, made clear that with regard to the other condition, it is made clear that the petitioner, the other condition with regard to the petitioner not leaving the jurisdiction of the special court is also relaxed, subject to the petitioner not leaving the Andaman and Nicobar Islands during the course of trial. Stop. Much obliged.
Deeply obliged.
Item number 4, the application for 2024
My lord, I am appearing for the petitioner, my lord. This is that matter, my lord, where uh, guest lecturers who were working in the college were not given the age relaxation in terms of the notification dated 19 September 2011, my lord. And yesterday I have said, my lord, after the order passed by the London Tribunal, the administration has issued an order whereby they have accepted the orders of the court and given relaxation to those part-time, the benefit of the said circular, my lord.
Which is a relevant paragraph 3.
My lord, paragraph 3, my lord.
Yes, so if we recall the facts were that you wanted those marks
My lord, zero.
as a 0.1.
Consequential relief, my lord, I have not paid before the tribunal, my lord. But since, my lord, that when they have accepted that circular, that ought to be in toto, my lord. In terms of the circular, those who are covered by the circular, for them it is 0.2 mark. That is in the advertisement, my lord.
Yes, which page
At
is
page number 76, clause 9, my lord.
on the basis of the certificates
Yes, my lord.
issued by the head of the institution and countersigned by,
My lord, that,
Yes.
that is always there, my lord, that.
yes, Mr. Chakraborty, what do you?
My lord, I have sought instructions.
Yes,
My lord, these are, my instructions are, my lords, these are two separate aspects, because my lords, the 19 September 2011 circular talks about age relaxation, my lord. That by virtue of this notification which has been shared, or rather the circular which has been shared, that benefit of age relaxation has been also given to part-time employees. However, this, so far as clause 9 is concerned, this is on the aspect of what is the marking for the experience. So for example, even if assuming that age relaxation is given across the board to all employees, contractual employees, part-time employees, does not mean that part-time employees and persons who are in permanent employment are still placed at the same level so far as the value that is to be attached to their experience is concerned.
no, the clause 9, sorry, clause 9 of page 76 doesn't talk of the same level.
No, it says,
Just says that 0.1 for part-time and 0.2
Yes.
for,
so exactly, so this is what is being followed. What they are seeking is, they are saying that instead of 0.1 for part-time, they should be given 0.2, which relief they haven't sought from the CAT. But in this writ petition, they are seeking this relief. Now, their logic is that because age relaxation is being extended to part-time, so as a consequence of that, the same marks also should be given for the experience of
Mr.
part-time.
Kumar, are you asking for 0.2?
Yes, my lord, because my rejection at 101, if my lord sees, page 101.
We'll come back to it. Yes.
So therefore, now this is a relief which they haven't sought from the CAT.
Yes.
I'm told there are other applications which are pending where this relief has been sought and the CAT has not yet adjudicated on that. If they have to seek this relief, they have to go back to the CAT, because this relief, this is not, it doesn't flow naturally.
Page 139 is your relief.
Prayers are at 48.
Yes, my lord, 139,
139,
my lord.
yes. Yes,
So this doesn't follow so naturally, because you could give age relaxation to all employees, but you can still add more value to somebody who is a permanent employee than somebody who is a part-time employee. That's a separate criteria. the validity of this has to be tested independently. So therefore, my lords, my humble submission will be that this is for the cat, or otherwise, my lords, we'll have to address it before your lordships. Opportunity may be granted to file an affidavit. If, but my lords, since it's an appeal, my lords, it should.
Yes, Mr. Chakraborty, apart from this circular, what has been shown to us, is there any decision of the administration with regard to this 0.1, the marking parity between full-time and?
That is the vacancy notice, my lords. That clause itself shows 0.1 and 0.2. And there are large number of original applications are pending in the CAT where they are seeking this relief. Now that has not been decided,
Mr. Chakraborty, only one thing.
my lord,
Clause 9 at page 76 says
my lord.
experience marks will be calculated 0.21 marks per month for full-time basis
My lord,
and 0.1 for part-time basis.
my lord,
So they were impaneled as guest faculty
My
teachers. So whether you have taken any, the administration has taken any decision as to whether these guest faculty teachers are or will be awarded marks as applicable to full-time basis.
no,
Or
our
any
decision
has been
yes,
taken?
yes, that is what he's challenging, my lord. That decision, my lord, is that according to the decision was that they will be given 0.1,
Where
not
is that?
0.2.
Where is that decision?
That decision, my lord, is there, my lord. I'll just point out. So it's
So we only have clause 9 in front of us.
yes, my lord. That decision is there, my lord. One second, I'll just point out. That has been annexed, in fact, page 102. Page 102, annexure 8 and collie. This document has been, this is perhaps from the website.
My rejection, my lord. That is what I was showing much to my lord.
That's right. I'm only showing that this is the experience at the rate of 0.1. So first point, according
This is
to
my rejection. That is
this
what
is the
challenge.
this is what they challenge.
But you did not challenge this in the CAT, in the tribunal.
Yes, my lord. This was challenge, and the tribunal arrived to the finding that I am covered by 19 September 2011 circular. Now, my lord, the second part, that experience part, I have not prayed, my lord. If my lord sees my rejection at page 102, these are two parts are there. First, I am not covered by 19 September 2011 and therefore 0.1 mark. And now my lord will find that my experience certificate, which was issued by the authorities, my lord will find this is that I am working from 8 to 4 p.m. That the tribunal has taken note of.
The experience
It was there, my lord, page 79, my lords will see it is not even but continuous, but I have not challenged it, so my lords today I cannot.
Page
79, the certificate.
Last second paragraph, my lord, may kindly
Yes.
have a look.
But this is,
You are Shakti Priya.
Yes.
not even continuous. There is a break of 2-3 months also in between.
Yes, but you also have not challenged this.
No, I have not challenged the CAT order, but the second part, my lords, the vacancy notice clause is where there are, that has to be struck down, my lord. It has to be read to mean that point because age relaxation is given, so therefore point to the same marks will also be given for part-time, my lords. That, my lords, my humble submission, my lord, that would amount to rewriting the vacancy circular, my lord. At least one opportunity should be granted for us to defend that.
Yes, come. The judgment and order dated October 18, 2023, passed by the Central Administrative Tribunal, within bracket for short, the tribunal, is under challenge in this application under Article 226 of the Constitution of India at the instance of the original applicant in OA 351/01020/2023/AN. The petitioner was empaneled as a guest faculty in commerce. Full stop. Pursuant to a vacancy notice dated May 10, 2023 for the postgraduate teachers, including 2 posts of postgraduate teacher in commerce, petitioner applied for the said post, for the post of postgraduate teacher in commerce. The petitioner's candidature was initially rejected by the authorities on twofold grounds. Number one, that the petitioner is overaged, and number two, that she is entitled to 0.1 marks for every completed month of service on the ground of experience. Full stop. Petitioner approached the tribunal challenging the action of the authorities in not according age relaxation in terms of the circular dated 19th of September 2011 issued by the Andaman and Nicobar administration. Full stop. The tribunal, by the impugned judgment and order, directed the respondent administration to consider granting relaxation in age to the applicant in terms of the provisions contained in the circular dated September 19, 2011. Challenging the said order, the petitioner has approached this court. Mr. Kumar Lanet Counsel, representing the petitioner, submits that since the authorities were directed to grant age relaxation in terms of the circular dated September 19, 2011, the administration should also be directed to award marks on experience, considering the petitioner to have rendered his service on full-time basis. Full stop. Paragraph. Mr. Chakraborty, representing the Andaman administration, submits that such issue was neither raised before the tribunal and therefore was not raised before the tribunal, and therefore this court cannot decide such issue, as the same involves adjudication of disputed questions of fact. So, heard the learned advocates for the parties and perused the materials placed. After going through the materials on record, this court finds that the petitioner was impaneled as guest faculty from time to time. From the office order number 145 dated August 2, 2022, which is appearing at page 70 of the writ petition, this court finds that the authorities, this court finds that the impaneled guest faculties were entitled to honorarium at the rate of rupees 1,000 per lecture, with a ceiling of rupees 25,000 per month. Full stop. Paragraph. From the vacancy notice dated May 10, 2023, at clause 9 thereof, it appears that experience marks will be calculated as 0.2 marks per month for full-time basis and 0.1 marks for part-time basis for the service rendered in a government/recognized school/government-recognized college on the basis of the certificate issued by the respective issued by the head of the respective institutions. Full stop. The entitlement of the petitioner to the entitlement of the petitioner to marks on experience shall depend whether the petitioner's engagement was on full-time basis or for part-time basis. Such issue involves adjudication of mixed question of law and fact, this court cannot decide the same, more particularly because such issue was not raised before the learned tribunal. That apart, the tribunal has granted full relief in favor of the petitioner, comma, petitioner cannot be said to be a person aggrieved in order to maintain this writ petition. Paragraph, for such reason, this court is not inclined to grant final relief in favor of the, is not inclined to grant any final relief in favor of the petitioner. Full stop. WPA number such and such stands disposed of, giving liberty to the petitioner to work out his remedies in the manner known to law.
My lord, I am grateful.
No written submissions.
Item number 5, WPCT 79 of 2023.
My lord, I am appearing for the petition, my lord. This petition was inducted as a constable in the IRBN.
Just 1 minute, please.
My lord.
Let us have the case. Yes,
My lord, on 12th of December 2002, he was appointed as constable under the Indian Reserve Battalion, my lord. My lord, 2012, he was posted in the headquarters at Port Blair, my lord, South Oman. There he was entangled. First, a NCFIR was initiated against him.
what is NCFIR?
NCFIR, non-cognizable offence.
Non-cognizant.
Yes, my lord, was initiated against him on 14th of January 2012, my lord. Subsequently, on 31st of January 2012, an FIR under section 354, 506 and 323 was initiated against him, my lord, with regard to outraging the modesty of a woman. Now, my lord, this was not in the course of the employment, my lord. It was pertaining to the place where he was residing. There was some issue and this was initiated, my lord. On the basis of inception of this FIR on 31st of January 2012, he was suspended on 1st of February 2012, my lord.
Yes,
6th of February 2013, a disciplinary proceeding was initiated against him, my lord.
yes,
He denied the charges against him, my lord, once he received the, I am sorry, my lord, the disciplinary proceeding was initiated on the 24th of January 2023.
24th January
Yes, my lord.
2012.
2012, my lord. 2013, I am just, 2013, my lord. 24th of January 2013.
Yes,
Now, my lord, I submitted a reply on 6th of February 2013, categorically denying all the charges against me, my lord. Thereafter, my lord, the proceeding pursued, my lord, and during the proceeding, the de facto complainant and her husband examined. The moment they examined, my lord, by that time, 2-year time was passed, my lord, he was even not getting any payment. He filed an application before the inquiry officer stating that what criminal act I have done, my lord, they have pardoned me, the persons have pardoned me, and because of this,
we can't understand.
my lord, he says that he submitted a petition stating that the de facto complainant has pardoned me from the act which allegedly I have committed.
Yes,
And because of the tendency of this proceeding from last 2 years, I did not able to maintain my family. My wife left me.
yes.
And on this score, he said that
No, when you say maintaining my family, it means economically.
economically, my lord, economically.
Yes,
So economically, my lord. So therefore, my lord, he prayed he may be exonerated from the charge so that he may insert in service. Now, my lord, on the basis of this letter, taking the first part of the letter, whereby he said that I am accepting my guilt, they concluded the disciplinary proceeding. Concluded the disciplinary proceeding, inquiry officer submitted a report. On the basis of that, the punishment of dismissal was issued, my lord. The punishment of
When did all this happen?
sorry, my lord,
When did all this happen?
on 28th of February 2014, he was dismissed from service.
Well,
He challenged it before the appellate authority. Mechanically, appellate authority dismissed the appeal on 7th June 2014.
yes.
My lord, the criminal proceeding which was on, my lord, on the basis of the complaint, my lord, that culminated on 14th of November 2017 in acquittal, my lord.
Yes.
After the acquittal, my lord, he filed a review petition before the authority saying that I have been acquitted from the criminal charges. Kindly consider and reinstate me in service. That was, my lord, rejected on 7th March 2018.
Yes.
Thereafter, my lord, he approached the tribunal and the tribunal dismissed the original application. First, my lord, I will show the charges against him, page 67, my lord.
So what is your ground against, ground for assailing the tribunal's order?
My lord, my grounds is, my lord, first of all,
We will hear you, but we just
yes,
want to understand.
the grounds is, my lord, the application which I have made before the inquiry officer, it has two parts. They have taken only the first part which suited them and dismissed me from service. And only on the basis of the same, no further proceeding was held and I have been dismissed. This is one part of my
And
sentence.
what is the second part?
Second part is that, my lord, in a recent judgment, Supreme Court has said, if a person is acquitted from the charges, that is of 4th December 2023, my lord, that has to be taken into consideration. In that case also, my lord, what happened? Disciplinary authority dismissing from service, he was also a police constable, appellate authority affirmed him. Trial court convicted him. Appellate court set aside the conviction. After the appellate court set aside the conviction, he filed a review before the disciplinary authority saying that I have been acquitted, kindly consider this. Now, my lord, the authority did not consider it and he was the order of the disciplinary and appellate authority remained. He challenged it. Ultimately, my lord, he filed a writ petition, writ dismiss, writ appeal, dismiss. He filed SLP before the Supreme Court. The Supreme Court, by taking into the consideration subsequent acquittal, Supreme Court said, my lord, it is not that honorable acquittal is required. Once a person is acquitted, we have to go by the nomenclature that he has been acquitted. This technicality will not come into way, and the Supreme Court set aside all the orders, directed to reinstate me in service with all consequential benefit, even back wages, my lord. Upon the said, my lord, the factual aspect of this case is apt.
No, so that is fine. We will see the decision. But you said that they have ignored the second part of the application and proceeded.
Yes, my lord.
What was the second?
Second part, I said, my lord, if my lord once come to that level, my lord, at page 85A, my lord.
Yes.
My lord, it says, my lord, I am so and so suspended that to submit on the above memorandum that I am accused of the allegation whatever leveled on the Article 1 and 2. But, sir, both the parties have withdrawn their respective case from the court after foregoing me on my apology. Sir, after this incident, about 2.5 years have passed on my suspension, and my wife has left me and went away to mainland because of insufficient salary to look after my family. Sir, I wish to correct myself in my life and in full hand. I submit that I will not repeat this incident in future. So it is requested to forgive me and kindly place me in my service.
Yes.
So, my lord, there are two parts of the letter. They have only considered the first part. And, my lord, the punishment is disproportionate, my lord.
On what basis are you saying it's
My
disproportionate?
lord, can you see the allegation, my lord, at page 67? Relevant would be, my lord, at page 68. This is the charge memorandum.
And where is the acquittal?
Acquittal, my lord, that starts from page 94, my lord. Relevant would be page 101.
And where is the dismissal?
My lord, page 86, my lord. Relevant at page 87, my lord, last paragraph. No reason was assigned, my lord. Only a stereotype. They have written that it will be give wrong signal to the society.
Yes. What else?
The appellate authority, my lord, and review, I will
Yes,
just place,
yes.
my lord. Page 91, my lord. Relevant is paragraph number 6, page 92. Punishment नहीं कर सकते.
Yes.
Thereafter, my lord, this review rejection on 1st March 2018.
Where is that? After
Page
that.
115, my lord.
So the acquittal had already happened by then.
My lord, after the acquittal, I have filed this review application.
Yes.
My lord.
And then the cat.
My lord. My lord, their opposition at page 141. Clause 8, my lord.
In the tribunal.
In the tribunal.
Clause?
Clause 8, my lord. Inner page 6, running page 141.
Yes.
They said, my lord, the inquiry conducted and submitted his finding on so and so. The charge officer has voluntarily admitted all the charge framed against him.
Hmm. Cat order starts at 179.
My lord. Cat order.
1 second. 1 second.
Several judgments were referred and thereafter on the basis of those,
There is no procedural lapse. That is what CAT holds.
yes. It's a major proceeding under Rule 14 of CCA rule.
And where does it take note of the acquittal?
Yes, my lord, at page, it starts with at page 183, my lord. 5.1.
You wanted to rely on state of Karnataka versus Umesh? Or some other judgment?
No, my lord, this
Very good, yes.
4th December 2023, Ramlal versus Union of
That's been
State of.
taken note of by CAT.
No, no, my lord, this was in
Recent.
on 4th.
No, but where does it consider, just states that you have been acquitted, but after that, where does?
No, no, nothing. No, no, 5.2 only for the purpose of consideration whether a fresh OA has to be filed or on the said OA.
No, I'm saying that, that point was decided in your favor.
Yes,
That is
yes,
not
ma'am.
part by limitation.
But on merit, it was not decided, ma'am.
Yes, says from proceeding in the exercise of disciplinary jurisdiction. Umesh,
Yes.
David, what else, Mr.
My lord, I am just relying only this judgment, my lord. My lord may kindly have a. I'm just only referring to relevant paragraphs, my lord. My lord, paragraph number 2 is the charges against him, my lord. Thereafter, paragraph number 5 records about his dismissal from service, affirmation by the appellate authority, my lord. Paragraph number 6 deals with his conviction and subsequently acquittal by the appellate court, my lord. Thereafter, my lord, paragraph number 9, question for consideration, my lord.
Yes.
2 questions were framed, my lord. Whether the dismissal of the appellant from service pursuant to the departmental inquiry was justified. On the fact of the case, what is the effect of acquittal order by the appellate judge in the criminal case on the order of dismissal passed by the departmental. Now, my lord, paragraph number 11, if my lord sees last 4 lines, it says that as part of that exercise, the court exercising power of judicial review are entitled to consider whether the findings of the disciplinary authority have ignored material evidence, and if it so finds, they are not powerless to interfere. Thereafter, my lord, paragraph number 13, my lord. It says, however, the charge in the departmental inquiry and the criminal court are identical or similar, and if the evidence, witnesses, and circumstances are one and the same, then the matter acquires a different dimension. If the court in judicial review conclude that the acquittal in the criminal proceeding was after full consideration of prosecution evidence and the prosecution miserably failed to prove the charges. In the court, in judicial review can grant redress in certain circumstances. The court will be entitled to exercise its discretion and grant relief if it conclude that allowing the finding of the disciplinary proceeding to stand will be unjust, unfair, and oppressive. Thereafter, my lord, kindly come to page 14, para 21.
Yes.
It says, my lord, with regard to that case, it is very clear that relevant so and so, my lord, and
What was the charge or same constable?
my lord, against him was, my lord, forgery,
Yes,
cheating and all, my lord.
yes,
420, 416, 768 and 71, my lord.
yes.
Now the court in para 21 records, if my lord sees a sentence, it says, inference has been drawn about the proof of the charge by ignoring crucial, relevant and material evidence which has come on record. Thereafter, my lord, the evidence of so and so, my lord, thereafter it says the disciplinary has merely retrieved the reasoning in the inquiry report. Equally so are the finding of the appellate authority. It is well settled that if the finding of the disciplinary authority are arrived at after ignoring the relevant material, the court in judicial review can interfere. It is only to satisfy ourselves to this extent. We are scrutinizing the material to see as to what was reflected in the record. We are satisfied that the disciplinary proceedings are vitiated and deserve to be quashed. Thereafter, my lord, para 23. With this above background, if we examine the criminal proceeding, the following factual position emerged. Thereafter, my lord, on the fact of those cases, my lord, can we come to para 24? It's the finding of the court, my lord.
Yes.
Here, my lord, the court says what is important to notice that the appellant has clearly recorded so and so, so and so. No doubt, the appellate judge says that it becomes doubtful whether the date of birth was so and that the accused was entitled to receive its benefit. However, what we are supposed to see is the substance of the judgment. A reading of the entire judgment clearly indicates that the appellant was acquitted after full consideration of the prosecution evidence and after noticing that the prosecution has miserably failed to prove the charge. Expression like benefit of doubt and honorably acquittal used in judgments are not to be understood as magic incantations. A court of law will not be carried away by the mere use of such terminology. In the present case, so and so, the conclusion that the acquittal in the criminal proceeding was after full consideration of the prosecution evidence and that the prosecution miserably failed to prove the charge can only be arrived at after reading the judgment in its entirety. The court in judicial review is obliged to examine the substance of the judgment and not go by the form of expression used. We are satisfied that the finding of the appellate judge in the criminal case clearly indicate that the charge against the appellant was not just not proved. In fact, the charge was to disprove by the very prosecution evidence. As held by this court, the fact is said to be disproved when after considering the matters before it, the court either believes it does not exist or consider its non-existence. So probably that a prudent man ought, under the circumstance of the particular case, act upon the supposition that it does not exist. A fact is said to be not true when it is neither proved nor disproved. We are additionally satisfied that in the teeth of the finding of the appellate judge, the disciplinary proceeding and the other part thereof cannot be allowed to stand. The charge were not similar but identical, and the evidence, witness, and circumstance were all the same. This is a case where, in exercise of our discretion, we pass the order of the disciplinary authority and the appellate authority, as allowing them to stand will be unfair, unjust, unfair, and oppressive. The case is very similar to the situation of GM Tank, and thereafter, my lord, operative portion, if my lord sees, paragraph number 30. It says, in view of the above, we declare that the order of termination dated, the order of appellate authority, the order dated so and so, refusing to consider and review the penalty are all illegal and untenable. Accordingly, we set aside the judgment. We direct that the appellant shall be reinstated with all consequential benefit, including seniority, national promotion, fitment of salary, and other benefit. As far as back wages are concerned, we are inclined to award appellant 50% of back wages. The directions we complied with within a period of so and so. So, my lord, here also similarly, after he was acquitted from the charges, he filed a review petition before the authority. And the authorities, my lord, by an order dated 7th.
Mr. Kumar, in your application, you have stated that the victim and whatever the lady's name was, and her husband have forgiven you.
Yes, my
All
lord.
right. Is that not at variance with your denying the charges?
No, this is what, because everything revolved around that letter, my lord, which has been written by him, my lord. And my lord, it has a second part also, they have not considered. More so, my lord, this punishment is,
Second part, you're only harping on your wife leaving you. That's the second part. What other part?
punishment is disproportionate, my lord. Similar set of witnesses were there in criminal, and if we go by that, because she was the de facto complainant, and her husband was also examined in the criminal trial. Despite of that, the court arrived to a finding that I am not. And my lord, I right now I don't have, my lord, the CCS rule, section 11, if my lord sees, rule 11, my lord, the dismissal could be perhaps when there is a case of misappropriation, and these are the exemption circumstances when a dismissal can be awarded, because I have seen the disciplinary proceeding was initiated under rule 14. So how this punishment can be imposed? Rule 11, my lord, proviso is there. And rule 14 says full-fledged inquiry, because it's a major penalty proceeding.
Rule 11 is promotion transfer while under punishment.
Punishment is there, my lord. Yes, penalty is there, my lord. Yes, my lord. If my lord find that the punishment clause 8 says removal from service. So 1
minute.
My lord, part 5, penalty and disciplinary authority. Section
Section?
11, my lord.
No, rule 11. we are-
Rule 11, I'm sorry, I'm absolutely.
Rule 11, clause 8.
Rule 11, my lord.
Yes.
It starts the following penalty for good and sufficient reason and hereby provided be imposed on a government servant. Got it, my lord?
Yes.
And my lord, may kindly come to subclause 8, my lord. Roman 8, my lord. It says removal from service. Very next page of the.
It was about of Boita. আমাদের একই বই দিয়েছে। Yes.
Here, my lord, it says penalty, my lord. But after subclause 8, my lord, may kindly come to subclause 8, my lord, next page, my lord. Removal from service, my lord.
Yes.
Service which shall not be disqualified for future employment under the employment, dismissal from service which shall ordinarily be disqualified for future employment. Provided that in every case in which disproportionate to known source of income or the charge of acceptable from any person of gratification other than legal obligation as a motive or reward for doing or failing to do any official act is established, the penalty mentioned in so and so shall be imposed. Provided further that in an exception case and for special reason regarding writing, any other penalty may be imposed. So, my lord, practically this punishment for dismissal ought to be in the cases where there is charges of disproportionate asset, my lord.
Anything else, Mr. Kumar?
Nothing, my lord. That's all.
Yes, Mr. Chakravarti.
My lords, the law, my lords, I feel, my lords, is largely a legal question, my lords. My lords, the law is well settled, my lords, in this field, and my lords, this is a case of outraging modesty of a woman. In a case of eve teasing, my lords, the law was laid down by the Supreme Court. This is a 2013 judgment as a recent to 2021. मेरे को copy देता है। मेरा copy देता है। My lord may have paragraphs number, this is a case of eve teasing, my lords, and prayer for reinstatement of service was made after acquittal. And my lords may see paras 24 to 28. Page 609. This is page 12 of the online version. The meaning of the expression honorable acquittal came up for consideration before this court in RBI versus Bhopal Singh Panchal. In that case, this court has considered the impact of regulation 46(4) dealing with honorable acquittal by criminal court on disciplinary proceedings. In that context, the court held that mere acquittal does not entitle an employee to reinstatement in service. The acquittal, it was held, has to be honorable. The expression honorable acquittal, acquittal of blame, fully exonerated or unknown to criminal procedure code or penal code, which are coined by judicial pronouncements. It is difficult to define precisely what is meant by the expression honorably acquitted. When the accused is acquitted after full consideration of prosecution evidence and the prosecution has miserably failed to prove the charges leveled against the accused, it can possibly be said that the accused was honorably acquitted. The same principle even in the judgment which my learned senior had cited. 25, in R.P. Kapoor, it was held that even in the case of acquittal, departmental proceedings may follow where the acquittal is other than honorable. In State of Assam versus such and such, this court quoted with approval views of Lord William J. and Robert Stuart versus Emperor. Then, my lords, that is set out. As we have already indicated above, in the absence of any provision in the service rules for reinstatement, if an employee is honorably acquitted by criminal court, no right is conferred on the employee to claim any benefit, including reinstatement. Reason is that the standard of proof required for holding a person guilty by a criminal court and the inquiry conducted by way of a disciplinary proceedings is entirely different. In a criminal case, the onus of establishing the guilt of the accused is on the prosecution, and if it fails to establish the guilt beyond reasonable doubt, the accused is assumed to be innocent. It is settled law that the strict burden of proof required to establish guilt in a criminal court is not required in a disciplinary proceeding, and preponderance of probabilities is sufficient. There may be cases. Yes. There may be cases where a person is acquitted for technical reasons or the prosecution giving up other witnesses since few of the other witnesses turned hostile. In the case on hand, the prosecution did not take steps to examine many of the crucial witnesses on the ground that complainant and his wife turned hostile. The court therefore acquitted the accused. We are not prepared to say that in the instant case the respondent was honorably acquitted by the criminal court, and even so is not entitled to claim reinstatement. Now, my lords will see, this is a very recent, my lords, judgment of the Supreme Court, 2021, my lords, where the law has been discussed. This is State of Rajasthan versus Him Singh. My lord may have paragraph 38. Which is at page 596. In the present case, we have an acquittal in a criminal trial on a charge of murder. The judgment of the Sessions Court is a reflection of vagaries of administration of criminal justice. Judgment contains a litany of hostile witnesses and of the star witness reciting from the statements. Our precedents indicate the acquittal in a criminal trial in such circumstances does not conclude a disciplinary proceeding. Then, my lords will see para 39 is the same judgment which I had cited, and paragraph 40, paragraphs on the next page. In the present case, the respondent was acquitted of charge of murder. Circumstances in which trial led to an acquittal have been elucidated in detail. Verdict of criminal trial did not conclude the disciplinary proceeding. The disciplinary inquiry was not governed by proof beyond reasonable doubt or by the rules of evidence which govern the criminal trial. 2, even on the more relaxed standard which governs the disciplinary inquiry, evidence of involvement of respondent in a conspiracy involving the death of Bhavar Singh would be difficult to prove, but there are, as we have seen earlier, circumstances emerging from the record of the disciplinary proceedings which bring legitimacy to the contention of the state that to reinstate such an employee back in service will erode the credibility of and public confidence in the image of the police force. Now, my lords may have the order, the findings, my lords. My lords may have the order of the criminal court for a moment. Page 93, it begins. And my lord may have page 98 first. The second last para. to attract the provision of section 451 IPC, or in order to sustain a charge under that provision, it is necessary to prove that accused has committed house trespass for committing any offence punishable. Then essential ingredients of offence under 554 are set out. Now, my lords may have page 99. In the instant case, it was the case of the prosecution that accused made house trespass to the house of the victim on 31st January 2012 at around 4:30 to 4:45, when the victim was alone in the room and was outraged her modesty. And thereafter, when he was apprehended by the victim and her husband, he threatened him with dire consequences and accordingly committed. It appears from the record the victim and her husband narrated the more or less uniform story before this court, though there were independent witnesses who were not examined by the prosecution. It is well settled that evidence of witness cannot be discarded merely on the ground that he or she is a related witness or sole witness or both, if otherwise the same are found credible. The witness could be a relative, but that does not mean to reject his statement in totality. In such a case, it is paramount duty of the court to be more careful in the matter of scrutiny of evidence of the interested witness, and if on such scrutiny it is found that evidence on record of such interested sole witnesses worth credence, the same would not be discarded merely on the ground witness is interested. Now kindly see after page 100, the next para. From the scrutiny of evidence of PW1 and PW2, it appears that victim PW1 in a cross-examination admitted that one of the neighbor also went out along with them to chase the accused and were running accordingly. However, the said neighbor was not examined by the prosecution. Husband of the victim PW2 in his examination in chief admitted that he took his child to a nearby carpenter shop at such and such on the date to pacify his cry, and the said carpenter shop was open. He also admitted in cross-examination that said carpenter also followed them while chasing the accused. However, the said carpenter was not examined by the prosecution. PW2 also admitted that his brother-in-law called the PCR van, but said brother-in-law was also not examined by the prosecution. One independent witness, Parvati, was examined, but she reported that she did not see any incident, did not know the accused. Also appears from inquiry report that we exhibit 2 herein that no external injuries were found on the person of the victim upon examination. Moreover, statement of the victim was not recorded under section 164 CRPC by any of the magistrate to corroborate the case. So therefore, my lords, the acquittal in this case is premised on the fact that certain vital witnesses were not examined by the prosecution. It is on that basis, my lords, that the prosecution, having failed to discharge the high burden of beyond reasonable doubt, that this person has been acquitted. Now, the test, my lords, or disciplinary proceeding is very different, my lords. The charges in the inquiry report, my lords, will see 155, the inquiry report begins. And eventually, my lords, the disciplinary authority is looking at, my lords, the high standards that are expected of the police force to maintain, my lords. The consideration is very different. It's a case of misconduct. They are not passing a punishment because of a charge of outraging the modesty of a woman. That is for the criminal code. My lords may see page 155, and my lords may then come to 159. The articles of charge are given, and at 159, my lords may see this is the letter, my lords, where he has pleaded guilty. Not just that letter which was shown by my learned senior. Kindly see page 159. This is 1st October 2013 letter. This is written to the inquiry officer, and kindly see what he says. With due respect, I want to say that I am pleading guilty of the charges levelled against me through Article 1 and Article 2 of the memorandum dated 24 January 2013. I assure you that I will not behave adversely and request yourself to forgive me. Now, kindly see Article 1 and Article 2. Kindly see article, this is at 156. Article 1 is on 14 January 2012, at about 1400 hours, he was found creating nuisance using unparliamentary words under influence of alcohol. There are two separate incidents against Srimati T. Parvati, wife of Sri Jagdish, and her daughter, threatening them with dire consequences. The first charge. Kindly see Article 2. This is what the criminal case deals with. Pradeep Kumar illegitimately entered inside the house of Srimati such and such while she was alone and tried to molest her modesty. Shri such and such husband rushed in, and then after that he was arrested. And this is so. Therefore, there are two separate charges. He's a repeat offender. And kindly, so after this, the second charge is the one which deals with the criminal proceeding. Now, kindly see after that page 160. 160, the basis, my lords. This is of course the letter of the inquiry officer to the commandant. And my lords may then see from the inquiry report, page 164, 161 it begins, and 164. Kindly see, this is very significant. 164, examination of PW2 Srimati Jai, such and such. I read over the statement recorded during the preliminary inquiry to her, and she stands on a statement, and she also identified her signature, which is marked as such and such. She also identified the person who entered his house and tried to molest her modesty. And then, of course, there is a conclusion is also based on his voluntary admission. Now, my lords, the disciplinary authority at page 167.
So how is 164 invoked, Mr. Chakraborty?
Because, my lords, the victim, so to say, or rather the person who has been has again, despite whatever maybe his letter that they have forgiven him, etc. But in the disciplinary proceedings upon examination, she has reiterated, and he has himself admitted. So, my lords, there is, because on some technical grounds he got acquittal from the criminal court because the prosecution didn't do its job. That is separate from proving the charges against him in the course of the disciplinary proceedings. And now, my lords, after that, 167 is, of course, the order passed by the disciplinary authority. And kindly see page 168. What is the charge on which he is being punished for in the disciplinary proceedings? I have carefully and dispassionately examined the service record of Pradeep Kumar and the findings submitted by the inquiry officer, and I am fully convinced that the charge officer is a habitual defaulter. So, being a member of a disciplined force, was responsible for protecting the life and honor of the citizens of the islands. However, instead of discharging his duty honestly and sincerely, he himself has indulged in criminal activities which is reprehensible and unbecoming of a member of a uniformed force. After such an act of gross misconduct, if he is allowed to continue in the battalion or showing even a bit of leniency towards him in this time would be a bad precedent and will encourage other members of the force to wrongly believe that such acts are minor delinquencies which could be overlooked. He has grave allegations leveled against him and repeatedly has displayed scant regard for authority or respect for women. Such element is not an asset to a disciplined force. His act of indiscipline has brought undesirable and negative impact on the organization.
Mr. Chakraborty, you have read that. How do you distinguish this Supreme Court judgment?
My lord, the Supreme Court judgment which has been cited doesn't say anything different from the judgments which I have also cited. Kindly see para 13 of, I think, unreported was given para 13. It's the reported is para 28. Expressions like benefit of doubt. This is the paragraph which.
No, what is the citation of the reported judgment?
Reported judgment is 2023 SCC online SC 1618. I can give. I think I have. Yes, I can order a copy of it.
1318.
My lord, I'll just hand over the
judgment to my lords.
No, the Ramlal.
Yes, Ramlal, I have.
I've got. I'll go.
Yes, it's 2023 HSCC 132.
Yes,
I'll
ma'am.
just-
But this, you have given us a Supreme Court copy.
Supreme Court dear.
Yes, madam.
Hey, I've just handed over the SCC. This is the SCC version. Kindly have paragraph number 28, which is at page 8 of the online downloaded copy. This says expressions like benefit of doubt and honorably acquitted used in judgments are not to be understood as magic incantations. A court of law will not be carried away by mere use of such terminology. In the present case, the appellate court has recorded that exhibit P3, the original mark sheet, carries the date of birth as such and such, and the same has also been proved by witnesses examined on behalf of the prosecution. The conclusion that the acquittal in the criminal proceeding was after full consideration of prosecution evidence, and that the prosecution miserably failed to prove the charge can only be arrived at after reading of the judgment in its entirety. The court in judicial review is obliged to examine the substance of the judgment and not go by the form of expression used. We are satisfied that the findings of the appellate judge in the criminal case clearly indicate that the charge against the appellant was not just not proved, in fact, the charge even stood disproved by the very prosecution evidence. As held by this court, a fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. So, my lords, in this case, the finding of the criminal court or the appellate court was such that not only was it proven that this person is not guilty, but it was proven that this person is, or it's almost like saying that it is not just that he is not a sinner, that he's a saint. So, my lord, this is the extent to which the appellate court, this is a case of forgery, was disproved to this extent. In the present case, the reading of the order of the trial court will show that it only says that with the evidence of the victim is consistent, her husband's evidence is consistent. There were these other people who the prosecution failed to examine. So therefore, the benefit of doubt is being given to the accused. So, my lords, that is very different from a case where, my lords, the appellate court has actually gone into the evidence and come to a conclusion that you have branded a saint to be a sinner, and this person is completely without any blemish. So, my lords, that in those circumstances, the court said that maybe technically the court has said that he's honorably acquitted. So, therefore, this judgment is not any different from the two judgments that I cited. Because only if on a reading of the decision of the criminal court, it is evident that there is no possibility that this person can be held to be guilty, will the decision of the criminal court have some binding impact on the decision? In any event, those two are also two judge benches which precede this decision. So, my lords, my humble submission is, my lords, that my lords, eventually it's maybe the cat, my lords, has kindly see the decision of the cat. It's not that the cat has not considered this aspect, because my lords, the cat.
We have seen paragraph 5.2.
Yes, my lords. So therefore, my lords, my humble submission, and I humbly submit that in the case of eve teasing, this person was dismissed. I don't, with the greatest of respect, that interpretation that a person can be dismissed only if it's a case of misappropriation of assets, my lords, that, my lords, in my humble submission, may not be the.
No, that is an interpretation given to clause 8 of rule 11.
Well, then I will, because the first case which I referred to is a case of a eve teasing, somebody is dismissed from service. But be that as it may, if that is seriously my learned senior is making that argument, then I will, my lord, I will come back with a judgment, because he hasn't produced any judgment to that effect. That's an interpretation of a.
Do you want a copy of the book? It's flagged.
This is on. Well, this, even on a plain reading, my lords, in my humble submission, this is an erroneous interpretation, because
Yes.
Roman 9 says dismissal from, this is one of the punishments. Roman 9 is dismissal from service, which shall ordinarily be a disqualification for future employment. And the proviso says, provided that in every case in which the charge of possession of assets disproportionate to known sources of income, or the charge of acceptance from any person or any gratification other than legal remuneration as a motive or reward for doing or forbearing to do an official act is established, the penalty mentioned in.
Yes.
So therefore, this means that in
That 8 and 9 will have to be given.
8 or 9 have to be applied where it is a case of disproportionate asset.
Yes.
Not only one thing, my lord,
Yes, yes.
judgment which my learned friend relied, that was
Yes.
taken note in the judgment which I have cited. my lord.
The one with
My learned friend heavily relied that of Deputy Inspector General of Police and Samudri Ram.
Yes, yes.
That has been taken note of the, and my lord, the judgment of the criminal court still holds good. They have not challenged it.
Yes.
So, and Rule 14, there are several subclause which has to be followed when you are passing a punishment of dismissal, my lord. Like in criminal trial, my lord, all the procedures are there. Only because a person has filed an application on the basis of that, whether they can pass an order of dismissal.
Where are your prayers, Mr.
Yes,
Kumar?
my lord. Yes,
Before the,
yes. my lord. This time all the prayers are there, my lord, I have seen.
Yes, page 180.
My lord. Yes, my lord, in page 48,
So memorandum, set aside the memorandum of charge.
yes, yes, they have short for
Then order dated 28th February is what?
dismissal order, my lord.
The dismissal.
Yes, my lord. Thereafter, appellate court's order,
Then 7/6/14 is the appellate court.
appellate court. Thereafter, review order, my lord.
That's the 7/3/2018.
My lord,
And then reinstatement.
reinstatement.
Even if you agree with your word, I have something to say. Very well. The present petition, the writ petition arises out of an order, judgment and order passed by the Central Administrative Tribunal on 28/8/2023, whereby the petitioner's original application for, inter alia, setting aside an order of dismissal passed by the disciplinary authority was, was rejected. Stop. The petitioner had also prayed for setting aside of the order of rejection of the appellate authority and the order of the appellate authority and the petitioner's application for review of that order. Stop. Next, learned counsel appearing for the parties have made their submissions and taken the court through the relevant material. Stop. Next. List this matter tomorrow under the heading for judgment.
Obliged.
Item number 6. Everything 36 of 2023.
800 chiller. 860 days in India, sir.
There's a delay.
Yes.
Yes, my lord. Says
Delay of
it was 860, but that does not take into account COVID. I mean, this is
COVID.
COVID. It was-
No, but then are you not covered by the Supreme Court orders?
My lords, that is discretionary because my lords, the Supreme, technically, my lords, the Supreme Court order would apply if that limitation expired during that duration. But my lords, in large number of cases, my lords, usually, my lords, that period is being benefit.
No, in this case, what is
The
the,
order is of 19 March 2021.
you're against the CAT order?
No, it's a mandamus appeal.
Oh, mandamus appeal.
So, they have filed an opposition, my lord, to our condemnation application. It's a ground of can application to go. Paragraph 2, my lord.
Nineteen March 2021, and when did you file it? 892 days.
If COVID is excluded, then
What are you saying? We can't hear you.
if COVID period is excluded, then this 891 includes.
What is the COVID period? According to you, when does that
March.
period end?
15 March 2020 to, it will be first of,
No,
first March 2023.
15 March 2020,
15 March 2020 to 1st March.
to 1st
2020.
March 2022.
Yes, my lord.
And when did you file this?
90 days from 1st March, so 30th of May 2020
90 days from 1st March.
becomes 30th of May.
And where have you said that? In paragraph 2.
We have not said about COVID in paragraph.
Not said it about COVID at all.
No, ma'am.
Yes, Mr. Kumar, what do you have to say?
My lord, I have strong objection, my lord. This order was passed on 19th of March 2021, my lord.
Yes.
What happened, my lord? Certain rights which were accrued to these employees, my lord, and they were getting the benefit. One fine day that has been snatched away by an order. We challenged it before this court. The writ court allowed our application and directed them to give the benefit as we were enjoying, my lord. Thereafter, I communicated this said order to them. Despite of communication, they have not done anything, my lord. Thereafter, again, my client.
When did you communicate? 19 March?
Immediately, my lord. Immediately, the order was passed on 19th March. I communicated on 3rd May 2021, my lord. The communication is there, my lord, annexure R4.
Yes.
Now, my lord, after the communication, they have not complied with the order. Subsequently, my lord, it is an autonomous body, my lord. They have taken in a resolution, if my lord comes to R5 of my opposition, my lord, they have accepted that they are going to comply with the order.
Petition is an autonomous body.
It's a
Petitioner is a
municipal council, my lord.
no, group of individuals.
No, my lord, the respondent administration, we are the employees of the autonomous body, Blair Municipal Council.
No, I'm looking at the list of respondents.
Respondent are working under the autonomous body, my lord.
Yes, but there's no autonomous body. It's just a group of respondents. It's just a group of individuals.
No, that is my client, my lord. The appellants before my lords
Yes.
is an autonomous body, my lord. Blair Municipal Council.
That's that appellate number 4.
Yes, my lord.
Yes.
Now, my lord, after this order, they have taken a resolution, page 44 of my reply, my lord, opposition, my lord.
For opposition.
My lord, I have used an opposition to this application.
Yes, page,
Page 44, my lord. It's an extract of the resolution dated, it starts from 43, 18th October 2022, my lord.
opposition টা কোথায় দেখো তো? Can two. Can one or can two আছে? হুম,
Pan 1, my lord.
Can one এর opposition.
One to the section.
December में file किया, December.
Office, এখানে তো নেই। What is the document?
My lord, that is a resolution adopted by the Port Blair Municipal Council, whereby they unanimously decided they are going to implement this order, 19th March 2021.
19 March.
2021, our order, my lord. Sorry, the order which is in our favor, my lord, of the writ court. On 18th October 2022,
When did they take that decision?
on 18th of October 2022, my lord.
Yes, they say that they will,
Implement the order of the
Yes.
writ court, my lord. After that also, when they did not implement it, my lord, we issued a notice saying that we are going to file a contempt application. Since, my lord, by that time the period for contempt was over, we taken out a writ petition again to implement the order on 18th September. Now, my lord, when I taken out the writ petition, my limit
in September of,
2023, my lord.
yes,
So when we taken out this writ petition, my learned friends appeared and seek for time, though there is no order. And thereafter, on 26th of September, this appeal was taken out. Now, my lord will find in the said application for condonation of delay at para 2, my lord, an averment was made, which is contrary to record, my lord.
yes,
At last 2 line, my lord.
yes,
Thereafter, the law department suggested to file appeal. In the meanwhile, certain papers were misplaced in the course of time. However, the certified copies is applied and is yet to be obtained. Now, my lord will find from the record, the certified copy was obtained on 16th April 2021, which my learned friend was placed. Now, my lord, kindly see in a note manner such application was in April 2021. 2021.
yes,
That is part of the record, my lord.
yes,
Now, my lord, kindly see their application, my lord. What sort of application is this, my lord, for condonation of delay? What is their ground? Kindly
yes,
see, my lord. And they have suppressed this fact that already I have filed a writ petition seeking implementation of this said order.
yes,
Now, my lord, kindly see para 2, it says, seeks to condonation of delay of days. It is submitted by the delay cause due to unavoidable circumstances, as after passing the order, the same is received by the department through its advocate, and on such the same was sent to the standing council PBMC for obtaining legal opinion. In the meanwhile, the advocate of the department changed and they have to travel frequently between mainland and island. Subsequently, the department sent the file to their advocate and followed time to time with
that's it, that we have read all this.
now, my lord, they have suppressed this fact also, my lord, that on 18th of October 2022, there was a resolution to implement this said order.
Yes,
Now, thereafter, my lord, can we see next 2 paragraphs? The other para 4, my lord.
yes,
The delay has been occasionally is due to the complexities arising out of the matter and due to various policy issues having huge ramifications, including economic consequences that have been required to be looked into in addition to delay in obtaining administrative approval. My lord, my respectful submission are, these are not the ground to take out a condonation of delay, more particularly when the autonomous body has decided to implement the order.
that is all?
Yes, my lord.
Kumar? Yes, yes,
When I was initially
March
submitting, 19 March 2021 was the order. It was the middle of the COVID period.
yes,
So if one excludes the period of the COVID duration, then the delay is of 121 days. So the delay, my lords, is of 121 days.
you are calculating from 1st March 2022.
No, it will from 1st of June 2022, because it is 90 days from if where the limitation expires between 15 March 2020 and 31st and 1st March 2022. In that case, the litigant is entitled to 90 days from 1st of March 2022, which expires on 31st of May 2022. So from 1st June 2022, the limitation will start running again. So my lords, from 1st June 2022 till the date of filing in September 2023, this
What is the date in September?
26th.
Yes.
so my lords, as per my calculation, my lords, it is 121 days. But my lords, my humble submission is that so far as the merits of the matter are concerned, our contention before the single judge was that the resolution is not binding. So that cannot be a ground, my lords, to say that because there was a resolution, it should have been complied with, because our contention is that the resolution was not approved by the administrator.
Can 1 of 2023 is an application for condonation of delay of 892 days on the part of the appellant in preferring the appeal from an order passed by by a learned single judge, from a judgment passed by a learned single judge on 19/3/2021. Order passed, 19/3/2021. Stop. Next, the ground for condemnation is stated in paragraph 2. Paragraphs 2, the grounds for condemnation are stated in paragraphs 2 and 4 of the application. Stop. The grounds are that the advocate and the standing counsel of the Port Blair Municipal Corporation took time for obtaining legal opinion, and the advocate also had to travel frequently between mainland and island, mainland and the A and N islands. Stop. The other statements relate to the further time taken on behalf of the advocate and the law department of the A&N administration. And last, that certain papers were misplaced in the course of time. Stop. The applicant/appellant also states that has also stated that the certified copies were applied for but could not be obtained. Stop. Paragraph 4 relates to the complexities, relates to the delay caused by reason of the complexities arising out of the matter and certain policy issues, including economic consequences. Stop. Next. Learned counsel appearing for the applicant/appellants also takes refuge under the pandemic and submits that the delay should actually be of about 121 days.
If the overseas, it has to be, because if it is from 1st June, it's filed, and even if it's 26 September 23 is the file. It is over a year still, so it has to be more than that.
Okay, what did I say? Learned counsel appearing for the applicant/appellants submits that the delay should actually be around 365 days, taking into account the pandemic in from 2021 onwards, from March 2021 onwards. Stop. Next, we find that the ground of COVID-19 has, however, not been taken either in paragraphs 2 or 4 of the application. Stop. Next, learned counsel appearing for the respondents takes strong objection to the plea or grounds, plea of delay or the grounds in support thereof. Stop. Counsel submits that there were several significant intervening factors, including of a resolution taken by the appellant number 4 / the Port Blair Municipal Council, that the council will implement municipal council, delete the next part, with regard to implementation of the order passed by the learned single judge. Stop. It is also submitted that the petitioners, that the respondents, within brackets, writ petitioners, close brackets, were constrained to file a second writ petition on 18/9/2023 by reason of the appellants, not by reason of the appellant number 4 not following up with the resolution for compliance. Stop. Counsel submits that the appellants sought for time when the second writ petition came up for hearing, and only thereafter filed the present appeal on 26/9/2023 along with the connected applications, including the application for condonation of delay. Stop. Next, we find from the narration of the relevant facts that the respondents with petitioners communicated the order in appeal dated 19/3/2021 to the appellants on 3/5/2021. Stop. The appellants, however, did not failed to take any steps for challenging the order till 26/9/2023, which is almost 2 years, 6 months later. Stop. The appellants also, apart from the failure to challenge the order, the appellant number 4 also took a resolution on 18/10/2022 for implementation of the directions contained in the order under appeal. Stop. The appellants, however, continued to drag their feet even thereafter, which forced the respondents / writ petitioners to file a second writ petition on 18/9/2023. Stop. The present appeal was filed on 26/9/2023 and appears to be more of an afterthought than any clear indication of the appellant's apostrophe keenness to challenge the impugned order or stop the consequences flowing from the impugned order. Stop. Next, we are our view is strengthened by the grounds stated, by the grounds offered for combination of the delay. Stop. There is absolutely no mention in the grounds of the pandemic or that the appellants are entitled to get any benefit therefrom. Stop. The only grounds given is are the usual delay caused by the representing counsel and the legal department of the party in question. Stop. Traveling from the islands to the mainland or non-availability of the certified copy of the order are no grounds at all for combination of delay. Stop. In any event, comma, it appears that the certified copy was made available to the appellants, was made available, delete to the appellants on 16/4/2021. Stop. Hence, comma, paragraph 2 contains a specific statement. Stop. Next, we also note with seriousness that we also note with concern that the application that the appellants have not suppressed filing of the second writ petition and also the resolution taken by the appellant number 4 on 18/10/2022, whereby the said appellant decided to comply with the order under appeal. Stop. These suppressions, the suppressions on these two counts are material for exercise of our discretion in convening the delay. Stop. Next, the subsequent modification of the period of delay from 892 days to 365 days is of no consequence, as that is not part of the pleadings or the grounds taken by the appellants. Stop. Next. It is commonplace. It is a commonplace consideration. Not okay. The consideration. Delete that, please. The consideration that vital rights may be created by reason of the delay in filing of an appeal is a guiding factor in allowing or rejecting the prayer for condemnation, stop. This also goes in, this consideration also goes against the appellants. Stop. Next, the above reasons persuade us to reject the prayer for condemnation of below. Stop. Can 1 of 2023 is accordingly rejected. Stop. What is can 2?
Stay.
Can 2 of 2023 follows the decision in can 1 of 2023 and is also rejected. Stop.
Appeal, my lord.
Yes, yes, MAT 36 of 2023 is accordingly dismissed for the above reasons.
Obliged.
Amrita Mela. Amrita, sorry.
Item number 7, everything 5 of 2024.
Order stand.
Mrs. Nag, your microphone, please. Yes.
The petitioners are working under a project, Sarva Siksha Abhiyan. They have sought for absorption in the education department, and there are other reliefs also for framing of scheme so that their pay protection can be there, etc., etc. Now, the Honorable Single Bench, Your Lordship, held that the application is not maintainable. I have to approach the tribunal because of my prayer.
Your prayer is for
Absorption. This I have to be taken by the education department. I have to be given appointment in the post which are vacant and against which I am working.
yes.
So that is the reason why the Honorable Single Bench held that the application is not maintainable. I have to approach the Central Administrative Tribunal. My point is that, Your Lordship, that it is not that what my prayer is. It's my position. I am not a government servant. And the state project is not notified under section 14 of the Administrative Tribunal Act. Under such circumstances, whether it can be said that I have to go before the tribunal for adjudication of the issue. This is the point. Your Lordship, I require a day's time because up to the point, Your Lordship, I have got a judgment, but due to some reason, Your Lordship, I'm not having in my file.
That's all right. So when do you want to come back?
Tomorrow.
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 And why don't you share the citation with Mr. Chakraborty?
I'll do that. Today itself, I'll do that.
So that we don't waste time.
Yes, Your Lordship.
Large number of similar matters have been entertained by the CAT and also by division benches of this court. So I'll also place.
Yes, okay.
It's a 3-page order.
Yes,
Your Lordship.
My copy has only 2 pages. The last page is missing.
2 pages only. It is 2 pages.
No, the
No,
copy thing.
no, accordingly, the writ petition is disposed of. My learned colleague does not have that.
I'll
Last
provide.
page.
Yes, Your Lordship, I'll provide you.
You can give a photocopy. Can we pass the? Can we pass?
Mr. Chakraborty, we will keep the matter tomorrow and I will,
No, the complete copy of the order
complete copy.
for his lordship.
Yes, list this matter tomorrow as paid for on behalf of the appellant.
Yeah, obliged.
Item number 8, 76 of 2024.
I brought it for time to the.
Please use the microphone, we can't hear you. You're the Appellant,
Lord, I'm appearing to the respondent number 2, my lord.
I on behalf of the
আরে সরো কিছু দেখতে পাচ্ছেন?
petitioner, my lord.
Yes,
I am for the appellant, my lord.
yes.
In this matter, I pray for time for, because the respondent number 2 is not, service is not effected. For the-
Number 3,
Two. One, my lord.
make up your mind. Which respondent?
Respondent number assistant labor commissioner,
There's no respondent number 3.
not only, one was not effected.
Lord, I'm
Two
appealing
is
for
my lord,
two.
two is effected.
I'm appealing for 2, who is an employee.
So you have not served one.
One, not such.
So when do you want to do it? It's in the appropriate only, when do you want to come back?
It's, because in this matter, the Malay advocate,
Lord, I request, Lord, it may be
PNB
taken in
also,
this circuit, my lord.
PNB also,
Yes,
I request this honorable court, my lord, that the matter be taken up this circuit, because it is a gratuity, under the gratuity act, an employee has been granted with certain gratuity benefits, and the bank authorities are dragging with the issues, my lord. The honorable single judge has decided the issues on the point of limiting.
it's an order of 23rd November 2023. Why you want to, why are you seeking time? We don't give time.
because my lord, the Malay advocate will be hearing.
No, you better come back tomorrow or day after, maximum day after.
Service was not effected.
Service, you do it in the course of the day, we will direct you by 5:30 PM. By 4:30 PM you serve. That is what we do in the principal bench. No adjournments. Not adjournments. Come back, serve by 4:30 PM, come back tomorrow.
Highly obliged.
Yes. Learned counsel opinion for the appellant. Appellants. Appellant seeks time on the ground of service not being effected on the respondent number 1. Respondent number 1 is the assistant labor commissioner.
Yes, my lord.
Yes, on the respondent number 1. Stop, next the respondent number 2 is represented.
Through SLSA, my lord.
Sorry,
Through State Legal Service Authority.
who is Mr. Sundara
He was an employee, my lord.
We can't hear you, microphone.
Lord, he was an employee of the bank.
Then
So-
what are you saying, SLSA?
State, because he has been I have been appointed to represent the 2 through State Legal Service Authority, my lord.
Yes, the respondent number 2 is, delete that, huh? The respondent number 2 is being represented by the Andaman and Nicobar Legal Services Authority. Stop. Next, list this matter on day after tomorrow. List this matter on, today's 1st February 2024.
Blair.
Service to be completed in the course of the day.
Item number 9, CPN 25 of Plan 23, with item number 10.
My lord, I sought instructions, my lord. Actually, my lord,
Microphone please, Mr. Chakraborty.
my lord, I have sought instructions, my lord. So
Yes.
the letters have been exchanged with the advocate on record in the Supreme Court, my lord. We are requesting for some time, my lord. Otherwise, my lord, so far as the
No, we will not give you that time, Mr. Chakraborty.
my
We are
lord,
making- Yes,
my second submission is, my lord, so far as the review and SLP is concerned, my lord, only in a situation where your lordships are allowing the review, it would have an impact because then the earlier order goes out of the picture. But if the review is dismissed, then, my lords, the SLP and review are independent proceedings. Yes.
both can't proceed simultaneously.
If your lordships dismisses it, then the earlier SLP is safe.
You can't do a tic-tac-toe and wait in the wings, which you will succeed in. You can't do that.
I will then argue the review, my lords. I'm only no other choice, my lords, because SLP is pending, my lords, so that in any event, my lords, if I succeed in my review, then SLP becomes infructuous. But if the review gets dismissed, then it doesn't affect the SLP because
Then why have you filed both? You
My-
could have first then filed the review and then waited for the decision in the review and then gone up before the Supreme Court.
review was filed first, my lords. However, my lords, then SLP was also filed, my lords, in because proceedings for contempt were pending, so well as both. Well, in that case, my lord,
Yes, Mr. Kumar,
My lord, I say, my lord, they can
yes, show us a letter from your advocate on record. When the SLP is due to come up, Mr.
that
Chakraborty.
he has not written, my lord, the unfortunate part.
Unfortunate part. Which is unfortunate, the SLP is not going to come up soon.
No, my lord, it's not mentioned. It's only says the defects have been removed and then it is, he
And when
confirmed
we filed the SLP,
in October 2023.
it was in 2023, October. And this letter is yesterday. So the defects have been removed in January 2024.
They have been refiled after that, my lords. It has been
Refiled when?
refiled yesterday.
Yesterday.
Yes, ma'am. Because I will then in that case place the review, my lord, and then whatever, my lords. If your lordship is with me, then of course my problem is resolved.
Yes, yes, Mr. Kumar, what do you have to say? 1 minute.
My lord, I say that they cannot use both the forum at a time, my lord.
Yes. The question before us, the issue, which is before us. No, just delete that. The, contempt relates to a judgment passed by a division bench on 25th November 2022. Stop. Both the learned judges have retired, and the content is now before us. And the petition is now before us. Stop. Next, we are informed that the alleged containers, how many of them? Alleged containers
One,
have none.
my lord.
No, the SLP is filed under the principal order, so the respondent has done.
Yes, we are informed that the respondents in the writ petition have challenged the judgment dated 25th November 2022 by way of a special leave petition. Stop. The special leave petition was filed in October. Only October, has to be after November.
October 23. it was.
Yes, was filed in October 2023. Did I say November 2022? 25th November 2022. October 2023. And that the respondents have also sought for review of this judgment. Stop. Next, the matter came up yesterday, and learned counsel opinion for the respondents slash review applicants was requested to take instructions on the status of the SLP. Stop. Council submits today that the defects in the SLP were removed as of yesterday, i.e. 29th January 2024, and that the SLP is now ready for, and that the SLP was refiled, re-filed also yesterday. Stop. Next, it is evident from the facts as, it is evident from the information placed before us, given to us, that the respondents slash review applicants slash alleged container has chosen to explore all possible options and also keep an exit route, ROUTE route, in the event the review fails. Stop. The hearers are unable to understand as to why the respondents would file the SLP as well as the review at the same point of time / together. Stop. In our understanding, Colin, the SLP would delete. Next. However, comma, we also note that counsel for the respondents is not in a position to indicate any possible time frame within which the SLP will be listed. Stop. We accordingly deem it fit to list this matter on after a week, on 6th February 2024, so that the respondents can give further clarity on the factual ambiguities. Stop. Next, list this matter on 6th February 2024. We propose to sit singly now. All right, otherwise we will not be able to progress at all with the single bench.
No, this matter, my lord, probably it can't be heard in any event right
So,
away.
call the next matter, please.
Item number 11. Here is DP on a.
May I please, Your Lordship? My lord, there are two appeals here. One is by a complainant, the other is by the state. Both of them arise out of a judgment of acquittal in a criminal case which started out as a case of murder, dragged for 16 years.
No, but
and innocent acquittal.
Sujit Kumar Samuel and the other one is N. Joes or whatever the name is. The two individuals.
No, the first one, Sujit Kumar Samuel, is the
Yes.
brother of the deceased.
Yes,
He has filed an appeal on behalf of the victim.
yes,
So that is an appeal under 372 proviso to the CRPC. The
yes,
second appeal is the one filed by the state, which is against M. Jose. M. Jose is an accused.
yes.
Here, in fact, my name is wrongly put here as appearing for the respondents because I don't appear for the accused. I appear for the complainant in the first appeal. The accused persons are represented by Mr. Tabriz and Mr. Binu.
Yes,
Now, these two appeals are being heard out together with a common paper book. The situation here is that it was originally a case of murder, which went to trial for 16 years. The accused persons were police officers who are alleged to have beaten my brother to death.
no, so what is it that you want today, Miss?
This matter has been ready for hearing since February last year.
Yes.
Now, on the last occasion,
Your initial submission was that it can't be heard
I'm
today.
very much right. On the last occasion, the order passed by this honorable court was that the accused persons had to surrender and take bail from the learned trial court and appear for hearing. So
Yes,
the paper books are ready. We've been served with the paper books. My learned friends are appearing for the first time.
The paper book
Now,
are
this
given
is-
to us, my lord, it can be taken up tomorrow, my lord.
Excellent. Then tomorrow I'll start.
In fact, this SLP, this was filed, but we were not put to notice. So that notice has come to us recently last week. We have surrendered before the court below in terms of the direction of this honorable court, my lord, and we are appearing.
yes.
The paper book is supplied to us, my lord, paper book.
Yes, tell us when we will keep this.
Tomorrow, my lord, it will
Tomorrow.
start. my lord.
Tell me. Yes, the appellant in CRA DB 1 of 2023 is the brother of the deceased, DECEA, deceased. And the respondent in CRA DB 2 of 2023 is the accused person. Are the accused persons, respondents are the accused persons. Stop.
My lord, I may intervene in this CRA one. My name has been mentioned as lawyer for the respondents. State is a party. State has filed another appeal against the same judgment. So in that,
What is it that you want?
it is a pro forma respondent.
No, what did you say? Learning Council, next Learning Council opinion for the parties submit that paper book has been prepared in terms of a direction passed by a coordinate bench last year,
No, that's circuit.
in the last circuit. You said February last year, it's been ready for
My
hearing.
appeal was admitted in February.
Yes, in the last circuit, stop. Copies of the paper books should be served on the other parties in with the appeals. Stop. Next, this is matter tomorrow.
Obliged. For the state, my attendance may be recorded, madam. For CRA two.
Yes, record the appearance. We will decide accordingly.
My lord, there are several hearing matters pending, my lord, so.
In the single bench, single bench.
Yes.
What does that mean? You want to work late or you want to go off early?
No, my lord, we want to work.
You want to work until when?
At 4:30, my lord.
4:30. Very good. And you will be having lunch at 4:30.
No, my lord.
My lord, one suggestion subject to acceptance.
Yes,
My lord,
yes.
my lords can take the matters till 2 o'clock. And after 2, some matters can be taken up by both the parties are ready so that the others can be released and they can appear before the civil courts, my lord. Because my lord knows that the same set of lawyers appear before courts.
So, Mr. Douglas, we are more, we are familiar with this pro, but we are not familiar with Mr. Kumar's pro. Very well. Let us sit at around say 1 o'clock we will sit.
At Calcutta High Court, madam. It is in Calcutta High Court, the file. I'm lying.
But that file has to come to the Andaman Circuit Bench.
No, yes, madam. I want, that's my humble submission and prayer.
And who is appearing for the respondents?
Respondent Ilango, sir.
Sorry?
Ilango, sir, Advocate Ilango. And I am appearing in person in my matter.
Very well. I cannot make any commitments now because I will have to ask the Calcutta High Court to send it. Because then again I will go and the file will also follow me wherever I go.
No, actually, because I tried in.
Very well. We will see. Yes, any other mention?
Well, I'm mentioning two matters, my lord, out of the list.
Thank you.
We listed day after tomorrow.
By out of the list by day after tomorrow? Who is the respondent? Who is your other
Ms.
side?
Jinu. Ms.
One
Jinu.
of the, in one case, I'm the respondent. I have no issues with the.
And another matter, Mr. Shivabalan is for the respondent.
Yes, sir. Why do you want it day after tomorrow?
Let it be tomorrow. Yes, sir.
Yes, it's a writ petition.
Repetition.
Very well. Yes, Ms. Zini, wait. Day after tomorrow, very well. Day after tomorrow, first.
My lord, I want to mention these 5 matters which are ready matters, my lord. Actually, analogous matter is pending before my lords. And these sets of matters were before court number 2, my lord. I mentioned and released it today.
Right?
Because, my lord, the other matters are before my lords. Similar matter, my lord. Any order passed in my lord's list, it is there, my lord. So if any order is passed, then definitely it will.
No, which matter is connected?
My lord, in serial number, I am just giving it, my lord, because first one, my lord, it is connected with item number
18.
item number 18, and thereafter, my lord, the other matters are
18 here.
no.
Very well.
Thereafter,
When do you want to come back, Mr. Kumar?
tomorrow, my lord, if it is there, because it is coming under the heading hearing 47, 48. This one,
Hearing?
yes.
No, hearing I will take it up only on maybe Thursday. What is the urgency? It's of 2023. What is the urgency?
No, but it is pending for hearing day after tomorrow or next week as per my lord.
Very well. Fifth,
My lord.
of the, yes, call on the list.
My lord, these 2 contempt matters, my lord, these orders were passed by my lord, and I have filed a contempt application, my lord. Thereafter, the file was sent to Calcutta, but it was never listed, my lord.
Contempt application of which year?
This is of 2023, my lord. Order passed by my lord, affirmed by the division bench, my lord.
Yes, show me the order, please.
My lord, this is only mentioning slip. I will place the order also.
Yes, day after tomorrow.
My lord.
Call on the list, please.
Item number 1. Yeah, this is the pattern.
I agree with the statement.
My lord, an FIR was initiated under section
I
279.
can't hear you, Michael.
My lord, an FIR was initiated under section 279 and 304A, my lord.
Yes.
My lord, I was a driver of a bus, and in an accident, one of the passengers succumbed to death, my lord.
Yes.
And therefore, charge sheet was filed, followed by trial. I have been convicted by the trial court. I prefer an appeal. In appeal, affirm the order of the trial court, my lord. Against that, I have filed this revisional application, my lord.
Yes, where is the order?
Yes, my lord. Trial court order, my lord. It starts from page number 19 onwards, my lord.
19.
My lord. Page 20, it's an order dated 16th of April 2021. An ordering portion is at page 46, my lord, inner page 27 of the judgment.
46.
46, running page 46, my lord. Inner page 47 of the judgment, 27 of the judgment.
Yes. Yes.
My lord. Thereby he was convicted. Page 49, my lord, the conviction was,
No, what is page 45? What is, why are you pointing to page 45?
46, my lord, altering portion, my lord,
Yes,
and then after the punishment, my lord.
yes,
Punishment starts from page 49. Last paragraph.
yes,
That for the offence under section 279 of IPC, the convict is sentenced to punish of simple imprisonment for a term of 4 months. For the offence under section 337 IPC, the convict is sentenced to punishable of a simple imprisonment for a term of 4 months. For the offence under section 338, the convict is sentenced to so and so for a term. And for the offence under section 304A, the convict is sentenced to punishment of simple imprisonment for a period of 1 year, along with rupees 1 lakh rupees fine, out of which 100% shall be paid as compensation.
so 1 year, what, 2 months left now?
No, my lord, thereafter, my lord, under section 389, he was under, in bail.
Yes, yes, yes,
So, we challenge it before the appellate court, my lord, and the appellate court, if my lord sees the judgment of appellate court, it starts from page 51. Affirm the order passed by the trial court, my lord. At page
yes,
64 onwards, my lord, and dismiss the appeal, my lord.
yes. Yes,
My lord, here there is an interim order passed by this court, my lord, which is in existence till 31st, my lord.
sorry, there's a,
There is an interim order
yes,
passed by this honorable court, which is in existence up to 31st.
interim order of what?
My lord, I was allowed to continue with the brief, my lord, which was granted by the appellate forum, my lord.
Which order?
My lord,
18 December 2023.
18 December, my lord, there is an order.
Yes. So no, once we have granted bail, you pay for extension, what is it?
My lord, after the conviction, my lord, on the same day, the trial court has allowed me to, my 389, my lord, the trial court allowed me to, bail was allowed. After in the appeal, when I preferred an appeal, there I paid for an existing bail bond and the appellate court also allowed. So even after the conviction, as per the order of the appellate court, certain time period was given to me to surrender before the trial court. In the meanwhile, I appealed this court and this order was passed. What I am on, my lord, let this matter be taken up in the next week. Till such time, the interim order may be extended up to Monday or Tuesday.
So I don't understand. The judgment of the appeal court is 7th November 2023.
My lord,
7th November 2023, and when were you granted bail? When were you granted bail?
at the time when I filed the appeal, my lord, before
Very
the
well.
appellate court.
So the judgment of the appeal court, where is that ordering portion?
My lord, that portion is at
From page
64.
Yes.
65, my lord. the bunch-
You are directed to surrender.
Yes,
So at this time, you were already enjoying bail.
yes, my lord.
So you were directed to surrender
Yes,
within 1 month.
yes,
So this portion was extended by
lord.
the coordinate
my
bench.
lord. So I pray next week it may be taken up, my lord, till such time, because that interim,
So it's till 31st January.
31st January.
That's
So,
tomorrow.
yes, my lord. So I pray till next week, any
Yes,
date we will fix.
It can be extended, we can hear it out the matter next week.
Yes, learned counsel appearing for the revisionist. Seeks extension of the order passed by a coordinate bench on 18 December 2023, whereby The bail granted in favor of the petitioner was extended till 31st January 2024. Stop. Next, the state is represented. Stop. Next. List this matter on 5th February 2024. Stop. The bail order is extended. The order for bail is extended till, what is a good time, Mr. Kumar?
My lord, as per the, what comments to my lord that
Till, you want to take advantage of the leap year or no?
no, my lord,
No.
no.
List is extended till 28th February 2024.
My lord.
Stop.
Number 2, we are at section of plan 33.
Yes, Ms. Zinu, who was
Your Lordship, I
appearing?
have not been served with any copy of the application. So I
No
don't
one
know if
appears
it's
for
very-
the,
Perhaps this is from Calcutta. This council doesn't appear here.
sorry?
The council, Mr. Manas Jai Somkar, perhaps he belongs to Calcutta.
No one appears for the revisionist, for the petitioner. Stop. Learned counsel appearing for the state submits that the state has not been served with a copy of this
Regional.
revision.
Your lordship, the advocate, your lordship, for the appellant petitioner, your lordship, he's not well, your lordship, he cannot appear. If it would be urgent for a week, your lordship. So humble request, your lordship.
With that, adjournment is paid for on behalf
Yes, your lordship.
advocate on behalf of counsel who is to appear for the petitioner on the ground that counsel is presently not well. Stop. Next. This is matter before the next circuit bench.
Grateful, your lordship.
Next, a copy of the petition will be served, shall be served on the state by 5th February 2024. In the meantime,
Obliged.
Grateful, your lordship. Humbly obliged, your lordship.
Item number 3, WPA 1068 of plan 33.
Mr. K.M. Jayapal is appearing. I prefer on 1st February.
sorry,
Mr. Jayapal is appearing for writ petitioner. So it's out of session. It will be on 1st February.
yes, this is matter.
Direction for service upon the private respondent matter.
लेकिन कागज में the records show that the petitioner is not interested in proceeding with the writ petition with diligence. Stop. Next, there's no direction, Mr. Chakraborty.
Then my lord, then
Yes,
I'll take it.
list is matter. Adjournment is sought for on behalf of counsel appearing for the petitioner even to do. Stop. Next, list is matter before the next circuit bench.
Item number 4.
May it please, Your Lordship. I appear for the petitioner. My lord, I have filed an application challenging a charge sheet and a proceedings with the prayer for quashing. The matter initially came up on the 16th of January when the state was represented and the court wished to see the latest order of the sessions court, and it was adjourned. On the date it was adjourned, the complainant was also represented by Mr. Elango. The matter was to be taken up for consideration of an interim order. On that date, the state made a prayer that the counsel appearing would not be able to appear and the learned public prosecutor would appear. The matter was adjourned again. Now today the matter has appeared. Mr. Elango has been served. The state has been served. It can be heard of. Now,
But are they objecting to your prayer for hearing? Why are you giving me this history?
no, because again today I find one of the parties is not there.
Yes.
I appear for the state.
Which party is not there?
Mr. Elango has appeared. I've
For the
served him.
complainant,
I've served him already as per.
For the victim, for the victim.
for the victim, yes. Yes,
Petitioner is essentially a police driver. He is assigned as the official driver of the Deputy Superintendent of Police,
Mr. Kabir, microphone.
Madam, North and Middle Ambulance. Now, on a particular trip to Port Blair, he has an altercation with a sub-inspector of police at a police station over here, and he's only a police constable. The victim of this case is a friend who is called over to the police station and asked to sign a statement, which she does. The statement is a colorful version with allegations of rape, stalking, sexual harassment, confining her wrongfully, feeding her intoxicating substances, all sorts of things. Now, when this victim is forwarded to the magistrate, she says this is all untrue. The 164 statement.
This is all
Untrue.
untrue.
Page 44 is the 164 statement of the victim. Now, this man, because he has fallen afoul of that senior officer, he is taken into custody and brutally assaulted. Now, your lordships are aware that he has to be produced when he's in custody before a doctor. He is produced on the 21st of July before a doctor, and a manufactured statement is created in the morning.
Which year?
2023.
Yes.
He is produced before a doctor at 10 o'clock in the morning before being brought before the magistrate. A manufactured statement is created saying no injuries, nothing. When he is produced before the magistrate, he shows the magistrate the injuries all over his body which have been sustained by custodial torture. And the magistrate sends them back saying, please go and do a proper medical. That is at page 49.
Yes.
That is done at 3 o'clock in the afternoon on the same day where a detailed set of injuries is found. This man has been subject to a severe abuse of the process of a criminal proceeding. If your lordship goes through the materials of the case diary, the 164 statements, more importantly, the statements of the victim and the other witnesses who are supposed to corroborate the story of rape, your lordship would not find a whisper of the ingredients to make out this case. This entire allegation itself.
Where is the order on
Madam.
petition?
The order here is an order by which the matter has been committed to the Court of Sessions dated 7th of December. Because we didn't have the certified copy at that time, we have obtained it. This is the one, 8 of the other. This is the latest of the orders, 7th December. The Sessions Court receives the record from the magistrate on commitment, takes cognizance, and allows him to remain on the existing bail. He was granted bail right in the beginning because the court saw that the materials don't justify an offense at all, let alone an offense of rape. Now he.
All the chatting and sneezing lawyers, please leave the court. Now. Yes.
Now he has remained on bail all throughout.
Item number 5.
This,
11 of
my lords,
1994.
the last order may be seen, my lords. We had moved an application for vacating interim order and the earlier honorable bench had granted us liberty to renew that prayer, but in the meantime, our application for vacating was to be treated as an affidavit in opposition. And my lord, the petitioner will have to file a reply to that.
Item number 106 have similar issues are same in,
On 6 of today's list.
yes, 106, 106.
Yes.
And my lord, similar matters.
Come in the front, please.
Similar issue, two matters. I am for the petitioner in similar matter, two matters. One is listed in court number 2 and another one is not listed. So I'll be mentioning it tomorrow, my lord. Let this matter, if it is taken up together, I'll be obliged.
Can be taken up together, your lordship, when it can be disposed. I think so. Because even.
And in the meanwhile, my lord, I will use my affidavit in reply within a day or two, my lord. So any date may be fixed, my lord.
So your vacating application is affidavit in opposition.
Yes, my lord.
Yes, ma'am.
What is the issue involved?
My lords, this matter, my lords, this certain conditions have.
Whether the interim order could have been passed based on documents which were incorrectly placed by the petitioners.
My lords, it is.
That was the issue.
No, yes, my lords, because my lords, it was this concerns certain conditions which were imposed on to grant permit for plying auto rickshaws. Because in their in the writ petition, my lords, they contended that inter alia contended that those conditions were not there. Whereas, my lords, we have annexed those documents with the application to show that those conditions are in fact there. And the other issue was whether there is any legal sanctity to those conditions, my lords. Basically, my lords, the condition, the one condition was that our local islanders card is to be produced, and the second condition was that the person who owns the auto rickshaw only one permit per person, my lord. Certain measures were taken by the committee constituted under the Motor Vehicles Act. Now, of course, the legality of those, whether they have sanctity under the Motor Vehicles Act, is a legal question which has to be
It doesn't coincide with the motor vehicles.
so that is the question. So,
Yeah.
my lords,
Matter is because act cannot be amended by the authorities.
Very well. So, Mr. Kumar, you want to file a reply?
My lord.
And Mrs. Nag, you are appealing for who?
Petitioner, your lordship.
Petitioner. Item number, what is the item number?
5, my lord.
5 with 106. The last order, the order dated 19 January 2024, passed by a permanent bench, indicates that the application for vacating an order, an earlier order dated 10th January 2024, was to be treated as the affidavit in opposition to the writ petition. And the petitioners will also file their affidavits in reply within a specific time frame. Stop. Next, the petitioners seek extension of time to file the affidavit in reply. Stop. The affidavit in replies. Stop. The affidavit in replies shall be filed by within. Okay, give me a date, please.
31st or 2nd, first, my lord. First
is tomorrow.
Tomorrow, my lord. First, my lord.
By 1st February 2024. Stop. List this matter. So it will go under hearing then. List this matter on 2nd February 2024. Not 2nd February, 5th February 2024. Yes.
My lord, then I will seek time till 2nd of February, my lord.
After replies till 2nd.
My lord.
Till 2nd February 2024, this is matter on 5th February 2024.
Obliged.
What is the interim order which you want recalling of, Mr.
that they may be continued to,
Like
allowed to permitted to ply the vehicle.
they are auto drivers.
condition is that, my lord.
That's the last paragraph at page 2 of the order.
Yes, ma'am. But they'll not be, because their license has already been suspended by the order which has been.
Very well. Yes.
Item number 6, WPA 26 of 2024.
When Mr. Jaipal is appearing, I pray this matter may be fixed on first.
The orders. Adjournment is paid for on behalf of counsel appealing for the petitioner. Stop. List this matter on 5th February 2024.
Item number 7, WPA 47 of 2024.
My lord, I am appealing for the petitioner, my lord. Respondents have been directed to file a report.
Lordship, Shiva Balan sir is appearing for the respondent, Your Honor. He is not here.
Sorry?
Shiva Balan sir is appearing for the respondent, Your Lordship. He is not here. I am praying for not today.
Adjournment is paid for on behalf of counsel appearing for the respondents. Stop list this matter tomorrow. Stop. It appears that the respondents have not complied with the direction dated 18 January 2024, whereby the respondents were directed to submit a short report in the form of an affidavit on the final outcome of the representation made by the petitioner with the office of the SDO, South Andaman. Stop. Next, the respondents shall ensure compliance of this direction by tomorrow.
Obliged.
Item number 8, WPA 65 of 2024.
Item number 8 and 9 are similar. There were other matters also which have been disposed of. This is the other issue.
No, you are appearing for the petitioner. They need to come here, Miss.
Order.
Yes.
Huh.
Coordinate bench decided the issue.
Yes, Your Lordship. There were group of persons. They were allotted with shop rooms.
No, 1 minute. Where is that order passed by the coordinate bench?
I have given, Your Lordship. Just I'm handing over.
Yes, so you have filed an appeal against that,
My lord,
Mr. Chakravarti?
let it come tomorrow, my lord.
Microphone?
Yes, let
No,
it
the order dated 18 January records that. Records the submissions made on your behalf. Administration is in the process of filing an appeal.
My lords, whether it has been filed or not, my lords, may let it come tomorrow, my lords, I'll come back.
And affidavits are complete in the matter.
No, Your Lordship.
First time, no, there's a direction.
There, but they have not filed.
Not filed.
Yes,
Not today, my lords, tomorrow I'll come.
yes, so list this matter tomorrow as paid for on behalf of the respondents. It is not clear whether the respondents, whether the parties have complied with the direction for filing of affidavits as given in the order dated 18 January 2024. Stop. Learned counsel appealing for the respondent seeks to take instructions on whether the administration has challenged the order dated 21st December 2023. Stop.
Obliged.
Item number 10, WPS 77 of 594.
My lord, service is affected to the respondent number one. I am praying for next week any day.
I'm appearing for the state respondents.
When counsel appealing for the petitioner seeks time on the ground of service not being complete. A service not being completed on the respondents, stop. Next, this is matter on 5th February 2024. As paid for.
Item number 11.
Right, please, Your
WPS of 1024.
W. I'm sorry. This Mr. Depal is appearing, my lord, so we can first.
A general is paid for on behalf of counsel appealing for the petitioner. This is matter tomorrow. On 1st February 2024. As paid for.
Item number 12. WP 85 1024.
Appearing for the respondent.
In this matter, SK Goldar advocate is appearing. Mr. SK Goldar appearing for the petitioner. Let the matter be taken up tomorrow.
This is matter tomorrow as paid for on behalf of counsel appealing for the petition.
Published.
Item number 13. WP 90 of 1024.
My lord, I am appealing for the petitioner, my lord. I'm seeking for an interim order, my lord. Here, my lord, in the year 1990,
1 minute. What is the interim order you want?
my lord, they rejected my claim for the allotment of the
Give me
plot,
the page 40.
my lord. Page 143, my lord.
143,
My lord.
not page 39.
No, my lord. Prayer, my lord. I'm placing the document, my lord.
No, please. First
Yes.
your prayer, Mr.
My lord, my lord.
Kumar.
My lord, my lord.
You expect that the court will know the facts.
No, my lord.
Well, what is the interim order you want?
My lord, page 41, my lord, prayer E. E and F, my lord.
Yes, where is the interim order? Where is this impugned order?
Page 143, my lord.
Yes.
My lord.
23rd January.
My lord.
This was passed.
My lord, it was
Yes.
communicated on 25th of January.
Yes. Yes.
My lord, page 145 onwards. My lord, this is the second round of litigation, my lord.
Yes.
May I place the facts, my lord?
First, show me what's wrong with the interim order.
My lord,
This-
page 145, my lord,
Yes.
inwards. My lord will find at the bottom, my lord, and whereas complying to the direction at para 17 of the judgment and order dated 17 November 2023 passed by the Honorable High Court, Circuit Bench at Program, the department removed the padlock by the administration and making an inventory of the item found inside the unit on so and so in the presence of the partnership firm. Whereas for compliance or further direction of the Honorable High Court for further, the petitioners were given a personal hearing on 20th December 2023. Whereas the petitioner during the personal hearing in the oral and written submission repeated the submission made before the Honorable High Court in the number so and so and requested to change the constitution, transfer the ownership of the proprietorship to partnership firm and also added the new partner. And whereas after careful perusal of the records presented before me and the oral written submission made by the petitioner along with the submission made by the applicant in the written petition following is observed, but an agreement was executed between the Director of Industries and MS Sagar Engineering Industries proprietor Shri S. Babu while extending the lease term for second instance for a period of 5 years. But as per the agreement, the term of lease was extended for second term from 11th of January 2013 to 10th of January 2018. As per clause 1 of the lease agreement, the plot so assigned shall be used only for the purpose for which it is assigned, for setting up of manufacturing, steel fabrication and manufacturing of battery machines, steel furnitures, etc. As per the clause 3 of the lease agreement, the object of the lease will be the establishment of unit for manufacturing of steel fabrication and manufacturing of battery machines, steel furniture unit by the leasee. The leasee shall utilize the plot for no other purpose from the above mentioned without the prior written permission of the leaser. As per clause 10 of the lease agreement, the lease shall not assign or sublet his right under the present request of the leasehold plot or any portion thereof without the previous sanction of the leaser in writing. As per clause 9 of the developed plot in the industrial estate at BHATTACHARYA area so and so, the lease shall respect all established rights of way over the.
Don't read all this, not making.
These are the conditions, my lord.
Yes,
Now, they say that page 147,
yes,
the original lecee Sri Babu submitted an invitation to the Industrial Department on 29/12/2017. But the unit has implemented a partnership agreement by way of execution of a partnership deed before the sub-registrar Blair on 1st of January 2017. And includes a copy of the partnership agreement for information of the Bharat Code. Such action by the lessee is violating to clause 8 of the developed plots in the industrial estate at BHATTACHARYA area. Thereafter, we quoted this manner, and thereafter it says there was no contract between the respondent and petitioner, that is Sri A.M. Suresh Babu, filed before the Hon'ble High Court at Calcutta, and the authorities as per the previous agreement was executed with us Babu, so and so. But by the current submission to the department by letter dated so and so, it was revealed that the sub-allotment had changed its activity from manufacturing of steel fabrication and manufacturing of battery machineries, steel furniture to subcontract work at Coast Guard and so, and therefore violated clause 1 of the lease agreement. It has been clause so and so, what I have read, my lord. The object of the lease agreement.
Mr. Kumar, just tell me, what is the matter about? Why do you want to interim order?
My lord, the matter is, my lord, 1992, the plot was allotted for a proprietorship firm in the name of Sagar Engineering. My lord, for a period of 15 years.
Yes.
That was extended from time to time, and the last extension was up to October 2018. My lord, at the age of 75, this Babu entered into a partnership deed with the other two partners, and that was a registered document before the sub-registrar. And he accordingly, within his lease period, intimated the said change of constitution to the Directorate of Industry for the purpose of changing it from proprietorship to partnership firm, my lord. Now, my lord, this did not act in terms of his representation and in terms of his reminder which were given. Subsequently, my lord, on 26th of September,
Did not act means what? Did not come to a decision?
did not allow to change it, neither they rejected it.
What do you mean? So there was the decision or not?
No decision at all. No decision at all.
Yes.
Subsequently, my lord, on the premises that we are not carrying business activities from the said firm, on 26th of September 2019, our such allotment was cancelled by them. Thereafter, also correspondence were made. Ultimately, vacation notice was issued by them in 2021. That was challenged in a writ petition before this Hon'ble Court on several grounds, and one of the ground was that in the said extension lease agreement, there was an arbitration clause, my lord.
Yes.
And we have invoked the arbitration clause by paying for appointment of the arbitrator. And the court, by considering my writ petition, taken into consideration this aspect that there was an arbitration clause, and I have invoked the arbitration clause. The court directed them to open the lock of my premises and directed them that the arbitrator be appointed, and within such period it can be done. They challenge it before the division bench. Now, my lord, when they challenge it before division bench, my lord, the division bench arrived to a finding. No aspect the division bench accepted, my lord.
Yes.
The division bench said, admittedly from the different work orders, it clearly established that the petitioners are carrying the business continuously. This is first fact finding of the court. Second, the court arrived to a definite finding that during his lifetime, the proprietor, that S. Babu, has made an application before the authorities, and that is within the period of the lease, that to change the constitution. These two factors, the court categorically arrived to a finding was given. Now the court said the authorities, you consider the case of these petitioners
Yes.
for giving a fresh grant if they fulfill the condition, my lord. This was the order of the court.
Fulfill the condition of what?
Fulfill the condition for allotment.
Yes.
So, my lord, the court arrived to a definite finding that you give them a fresh grant if they fulfill the condition as per the requirement. Then you allot them, taking into consideration this fact that in his lifetime he has applied within the lease period, and second, they are carrying the business. So this was the direction. My lord, what they have done, they have turned back and they have started interpreting the earlier lease agreement and negated my claim. Whether it is permissible, my lord, after the order of the
Negated your claim.
Yes.
Your claim of carrying on a partnership business.
No, our claim was the court said you give them fresh allotment.
Yes.
If we fulfill the condition by taking into the facts which I have stated.
Yes.
Now, instead of considering whether I fulfill the condition to continue with the said firm and by entering into a new lease deal,
Yes.
they revert back and they started interpreting the earlier lease agreement and arrived to a finding that I am a defaulter, therefore it can't be done. Now, my lord, they have accepted the order of the division bench. Now, if my lord permit me, I will just place the order of the division bench, my lord.
For your interim order. Now.
Because, my lord, what the division bench has said, division bench said,
I have understood. Yes, where is the order?
my lord, kindly come to my lord, division bench order that is of 17th November at page 121. And relevant would be, my lord, from paragraph number 12 onwards, page 124.
Yes. Yes.
My lord, it says indisputably, as Babu did not apply for renewal of the lease after its expiry, the question of renewal of lease would be dependent upon the administration approving the change in constitution of the firm from partnership, proprietorship to partnership. Preamble, Mr. Babu was awaiting reply from the administration with regard to his prayer for reconstitution of the unit and amendment of the registration. Renewal of lease is essentially a fresh grant. Although it would have been prudent for us, Babu, to obtain a prior permission before the sole proprietorship was converted into to the partnership, we feel that the administration would have considered the case of reconstitution of the firm for a fresh grant of lease subject to the fulfillment of all conditions. It is not possible to hold that the unit was not functioning, having regard to the several documents, including some work orders issued by the government agencies. More so, a trespasser also cannot be forcibly evicted without following the due process of law. While there may not be any requirement for an arbitration as Mr. Babu has expired, we dispose of the appeal by directing the administration to consider the prayer for grant of fresh lease to the writ petitioner subject to the fulfillment of all conditions within a period of 6 weeks from the date of communication of this order, after giving a reasonable opportunity of hearing to the writ petitioner partnership firm. The administration in deciding the matter shall take into consideration the earlier release granted to S. Babu, and that S. Babu has during his lifetime informed the administration about the reconstitution of the business and was awaiting approval prior to his death. Moreover, it appears from record that till the possession was taken, the petitioner was executing various works of various government authorities. In fact, the first intimation was made within the year.
So after S. Babu died, the partnership firm was carrying on business.
My lord.
The two other partners.
My lord.
Yes.
Even during his lifetime was carrying, subsequently as Babu died in 2020, my lord, much after the partnership deed was constituted, my lord.
Yes.
Now, my lord, why I am harping for interim order? Because subsequently the court said, my lord, at paragraph number 18, till the authorities take a final decision, the writ petitioner shall be allowed to remain in possession of the property. This, however, did not create any right of equality. It is needless to mention that in the event renewal is not allowed in favor of the petitioner, the authorities shall take possession of the property within a period of 7 days from the date of communication of this order. That's why I am harping for an interim order.
So did the authority decide or not decide?
Decided, my lord, by this order rejected our claim by taking into consideration the earlier clauses of the earlier lease deed. Whereas the court said, you consider their case, since they are carrying the business, If they fulfill the condition, you allot him. If they are not fulfilling, you don't give it. But instead of, my lord, they have accepted the order. Once they have accepted the order, whether they can act contrary to the order and reject my claim. Admittedly, the plot is in possession from 1992 onwards.
Yes, very well. That is all, Mr.
Yes, my
Kumar?
lord, that is all. Because there is a clause that within 7 days we have to hand over.
Yes, and 7 days is gone.
No, my lord. 25th order was passed, 26th was on holiday, my lord. And thereafter, immediately yesterday I have taken out and I have also paid to dispense with. I have served also so that they can come, my lord.
Yes, Mr. Chakraborty.
My lords, this is the lease was executed in respect of, this is an industrial estate. My lord, these plots of land have been given at a throwaway. My lord, the lease is like 300 rupees per square feet or in that range. My lord, this was.
Mr. Chakraborty, let me do this. I will direct filing of affidavits.
My lord.
All right. And till the matter is heard out, you will not disturb the possession.
In any event, my lords, they can only be dispossessed in accordance with law, my lords.
Yes.
Even if interim order is not granted, my lords, even then, my lords, it has to be done under the estate. Earlier on, they had made that mistake. But subsequently, my lords, they will have to then take steps in accordance with law, my lords, under Public
Yes.
Premises Act or something.
Well, where is the order under challenge?
143, my lord, page number.
The writ petition is directed against an order passed by the Andaman and Nicobar Administration, Directorate of Industries on 23rd January 2024. Stop. The order was communicated to the petitioner on 25th January 2024. Stop. By the said order, comma. The lease granted in favor of the petitioner was found to be unlawful owing to the alleged violations caused by the petitioner or committed by the petitioner against the industrial estate rules and the lease agreement executed on 18 September 2015. Stop. You said it from 1992, you said.
Yes, my lord.
This
That
was
was an extension, my lord. That was an, I have used it.
2015, stop.
The lease had already expired, my lords. It's never extended.
The department also came, the department also came to the view, was of the view that a fresh agreement for grant of lease for a further period cannot be executed. And upheld the cancellation order dated 26 September 2019. Stop. Next, learned counsel appearing for the petitioner places an order passed by a coordinate bench, by a division bench on 17th November 2023 in an appeal filed by the administration against an order passed by a learned single judge on 18th August 2023. Stop. Council submits that the division bench directed that the petitioner shall be allowed to remain in possession, although that would not create any equity, was allowed to remain in possession. and that the authority will take possession of the property within 7 days in the event the authority disallows the renewal of lease in favor of the petitioner. Stop. Next, learned counsel, the administration is represented. Stop. Learned counsel submits that the petitioner, comma, in any event, comma, will not be dispossessed without authority of law. Stop. Next. Considering the relevant portions of the order passed by the division bench. Now, upon considering the relevant portions of the order passed by the division bench, comma, it appears to be evident, now it is evident, comma, prima facie, comma, that the petitioner carried on business from the leased property for a substantial number of years and was also in business when the order of cancellation was passed. At the time of order of cancellation on 26 September 2019. Stop. The division bench, the direction on the administration to allow the petitioner to remain in possession was presumably to be in place until the authority takes a decision on the grant of a fresh lease. Stop. Stop. Next, this decision was taken on 23rd January 2024 and communicated to the petitioner on 25th January 2024. Stop. Next. Until, considering all the appealing facts and circumstances, particularly the fact that the petitioner has been in possession of the leased property or the leased premises and has been carrying on business in that premises since
1992.
No, that's.
1992, my lord.
The sole proprietorship was kept.
since 1992, within brackets, initially in the form of a sole proprietorship concern, close brackets, comma, the petitioner, there shall be an interim order in terms of prayer E of the writ petition. Stop. Prayer F of the writ petition. Stop. The respondents shall not interfere with the possession of the petitioner firm in respect of the premises in dispute until the matter, until further orders are passed by the court after filing of affidavits. Stop. Next, affidavit in opposition by within
4 weeks, well,
4 weeks or 2 weeks? Within, what did you say, 2 or 4?
3 weeks. Well.
I'm not haggling with dates with time. Yes, affidavit in opposition within 4 weeks, reply within
1 week, my lord.
within a week thereafter. This is 4 weeks as paid for. Comma, reply within a week thereafter. Stop. This is matter. after 5 weeks.
Obliged.
Question number 40.
May please, Your Honor. My lord, I have challenged an order of the special judge Oxo Court by which the court has sought to invoke powers under the CRPC which he does not have. This is a case where there's a girl.
Where's your,
I don't have
Item number 50, WPA 915 of 2023.
My lord, in this matter, Mr. Sivabalan is appearing. He has
Yes,
requested.
matters which people, which council want to do today? Any other hearing? Which matter?
Item number 15.
15, very well, 15.
Several times has been granted to file the opposition, we are unable to file it. I want to dispose of my property by way of gift, deed.
Have you filed the appeal in opposition?
My lord, I'm a proxy counsel. Mr. V.D. Sivabalan is.
Yes, adjourned straight for on behalf of the, on behalf of council appearing for the respondents,
Respondent for administration.
for the administration, stop. The records in the file show that the respondents were directed to file their affidavit in opposition on 29 September 2023, within 2 weeks from that date, stop. The respondents sought for an extension on 22nd November 2023 to file their affidavit in opposition and was given 2 more weeks to do so. Stop. A third direction was passed on 9th January 2024, directing the respondents to file the affidavit in opposition by 22nd January 2024. Stop. Next. Counsel who seeks adjournment is not aware whether the respondents have filed the affidavit in opposition. Stop. There is in any event, there is no affidavit in opposition in the records of the court. Stop. Next, list this matter tomorrow. List this matter on 1st February 2024. Stop. The respondents shall pay costs which is blank, to blank, within the returnable date. Stop. Yes, any other
I
matter?
was just mentioning on item number 121, my interim order expires tomorrow. It's a case of demolition of my property. The lordships have been pleased to stay this by an order dated 11th January, but it expires.
Very well, tomorrow. Tomorrow it will be in the list. Item 121 of today.
Madam,
Yes.
would you
Tomorrow.
please to extend the interim order to them?
No. Well, without, the matter will be there tomorrow. Just take to open ticket the.
There's another matter for hearing, that is item number 57. I don't want to reawaken bad memories. The lordship would recall a couple of years back, there was a problem with the revenue forms. At that point of time, I had moved an application and my lord had been pleased to pass certain orders also in connection with that. That has again resulted in another round of litigation, the 8th round of litigation. But this has been pending now since 2021.
Mr. Kabir, let me see whether, if I can reach the matter this week or not. All right.
But your lordship has heard the matter.
Well, we shall see.
Not name. Item number 15, my lord. I pray for that.
You can't mention. Total costs and then come back.
No,
Total costs.
I'm sorry, my lord. It is